gentlemen, future attorneys, future advocates, prosecutors, magistrates, judges, etc., etc. Guys, let's go through Introduction to Law. We're going to go through Study Unit 3, titled The Story of Our Law. An overview, it says here, in this study unit, we will examine how South African law began. In this way, we shall see how our law came to be what it is today. As a prerequisite for your study of Study Unit 4 and 6, you need to have understanding of the history of South African law. And then it says here, please note, you will study the history of South African law in much more details in the modules Origins and Foundations of South African Law. Then there is a key question here. It says, after completion of this study unit, will you be able to explain the composition of South African law against its historical background? So that is one thing that you need to bear in mind. Whenever as we go through the study material, make sure that at the end of the day, you are in position to explain the composition of South African law against its historical background. Now, remember, this is on page 33, and then we will go all the way until page 41. Setting the scene, the history of our law. The Department of Justice is organizing a conference on the origins of African legal system. The aim of the conference is to find out how the different legal systems of the African continent began and how they have developed to suit ever-changing circumstances. Jane is asked to give the introductory paper for the session of South African law. She decided to start with a short history of the development of our law. However, it is not easy to present such a short history of our law because our law has developed over a period of more than 20 centuries. Hmm, Okay. Well, remember it comes from Roman law, Roman Dutch law. Yeah, so it makes sense why 20 centuries. Jane has to find a way to tell the story of the most important historical moments in our legal history. She has to do this without including too much details. And now we're moving on to page 34. There is an activity. Activity 3.1, it says, if you were attending the conference, what kind of information would you expect Jane to give in her paper on our legal history? Feedback. You'll probably want to know where and when our law started. You'd also want to know what happened after that and what influences were most important in developing and shaping the law. In the end, you'd want to know what our law looks like today. Quite a lot of us, or quite a lot for us to deal with. So let us get started. Now there is a discussion here. It says a three-layered cake. The history of our legal system goes right back to the Romans. It may be divided into three parts. Try to imagine a three-layered cake. So we're going to now go to the first layer of that cake. It says, number one, imagine that first layer of the imagine that the first layer to be the way in which Roman law came to form part of, okay, imagine the first layer to be the way in which Roman law came to form part of our law in Europe, or part of the law in Europe, and particularly how Roman law became part of the law in the Netherlands. This law in the Netherlands was to become known as a Roman Dutch law. The second layer of the cake, it says number two, Imagine the second layer to be the movement of Roman Dutch law from the Netherlands to Cape Town. Remember when Jan van Riebeeck came to Cape Town? In which year? I'm sure you remember it. It's 1652. Now we go into the third layer. It says here, finally, imagine the third layer of the way, or imagine the third layer to be the way that a Roman Dutch law developed after it had been brought from the Netherlands to the Cape. When doing this, we have to remember the importance of English law and indigenous or African customary law. This will be discussed a little bit later on. Now we're going to now go back to those layers and talk about them or talk about the details of each of those layers. We're starting with layer one. It says here, the first layer, Roman law became, or Roman law becomes a Roman Dutch law. It says here 753 BC to 472 AD, the Roman era. Let us begin with the first layer. Most people know something about the history of ancient Rome. They know how Rome took over much of the ancient world. In certain parts of the world today, we can still see the ruins of the magnificent buildings and cities which the Romans built in ancient times. Latin, which was the language used in the Roman Empire, is still studied at schools and universities and is still used as part of our legal language. One of the most important things which the Roman Empire gave us and which has lasted until today was its legal system. Roman law, culture, and authority were to play an important role in the lives of people in parts of what today is Europe, North Africa, and Asia. This was particularly during the time of the Roman empires. The history of Rome started in the 753 BC and ended in 476 AD. Then you are reminded that BC means before the birth of Christ and AD stands for after the birth of Christ. As you probably know, Christ was born during the time that Rome occupied Holy Land when Caesar Augustus was empire, height of a Roman Empire. When Roman Empire was at its height during the second half of the first century BC and for the first 2 centuries AD, it became the master of all the peoples around the Mediterranean Sea and even in parts of England and Asia. During this period, Roman civilization and Roman culture reached their highest level of development. Roman law also reached its peak. The achievement of the Roman law was the result mainly of the efforts of the Roman jurists. The Roman law that was applied during this period is usually referred to as the classic Roman law. Roman Empire split at the end of the 4th century AD. The Roman Empire split into two parts, a Western Roman Empire, which had Rome as its capital, and the Eastern Roman Empire, also known as the Byzantium, which had Byzantium, also called Constantinople, and nowadays called Istanbul, as its capital. After this period, Roman law began to decline. Western Roman Empire. Western Roman Empire, fall of Western Roman Empire, Roman law declines yet remains alive. Various Germanic tribes from Northern Europe, like the Goths and Franks, the so-called barbarians, gradually took over the Western Roman Empire, and in AD 476, a Germanic ruler came to the throne of Rome as a result of Germanic customs replaced Roman customs and Roman law became weaker, yet Roman law remained alive and this fact later on helped to make it easier helped to make easier the reception of Roman law in Europe. One of the reasons for this was that many of the Germanic rulers allowed their Roman subjects to be governed by Roman law. This law, however, was not the pure Roman law of ancient Rome, but Roman law which was influenced by Germanic law. Another and perhaps a more important reason for the survival of Roman Dutch law or Roman law was the part played by the Roman Catholic Church. Roman law formed the foundation of church law. This church law later became known as canon law. Special church courts decided not only on church matters but also on a number of everyday matters such as questions regarding marriages and the validity of contracts. Canon law had an important influence on the development of modern law. It is, for example, because of the canon law that we have inherited that a mere agreement between two people can be enforced by law. Eastern Roman Empire, Roman law survived successfully. The old classical Roman law survived more successfully in the Eastern Roman Empire than in the Western Roman Empire. The empire of the Eastern Roman law in the 60th century was called Justinian. He wanted his empire to be as glorious as the old Roman Empire, and he wanted to bring order to the legal system. In an effort to achieve this, he decided to codify Roman law as a whole. What what codify means was that he decided that all the earlier writings of the classic jurists and all the laws which had been passed during the time of the empires were to be collected and are written down as a code. This collection of Roman law by Justinian was called the Corpus Iuris Civilis. By codifying the law, Justinian kept Roman law alive in the Eastern Roman Empire. Although this collection of Roman law did not have much influence in the Western Roman Empire at that time, however, the fact that the Roman law had been collected and written down made it possible for Roman law to be received in Europe in about the 12th century AD. 12th century renewed interest, Roman law studied at medieval universities. In the 12th century, there was a renewed interest in Roman law. Medieval universities like the University of Bologna in Italy started studying Roman law as contained in Justinian's codification. It was because of these medieval universities that Roman law spread throughout empires or throughout Europe. However, it was really only later in the 15th, 16th, and 17th century that the true reception of Roman law took place in Europe. It is the reception of Roman law in the Netherlands that is particularly important for our story. Roman law was received into Europe at a time when the existing legal systems in Europe were unsystematic and unscientific. These systems were also fragmented. In other words, there were many different kinds of systems. Those medieval jurists who had studied Roman law knew that a legal system such as Roman law, with its scientific methods, was extremely desirable. Soon, these jurists began to look at the laws of their own countries through Roman eyes. In this way, they could see how what was lacking, or they could see how what was lacking in their own legal system could be improved through the use of the solutions contained in Roman law. In the whole of Western Europe, therefore, the use of Roman law to fulfill the needs of everyday legal practice pro- proved to be a force which united the legal systems of the different European countries. At the risk of oversimplification, we may say that if a particular problem in a particular place or region could be solved appropriately by a rule of the customary law of that particular place or region, or if there was no such a rule, jurists would look to Roman law for a solution. Roman law, as explained by the medieval jurists, would then become merged or joined with the existing law. In this way, most of what was contained in the codification of Justinian was received in Europe. In the Netherlands, it was the reception of Roman law that caused the creation of what was called Roman Dutch law. In the same way, Roman Roman French law, okay, in the same way, Roman French law, German law, and so on were created. In this way, a common Western legal tradition began in Europe. In the Netherlands, various jurists wrote commentaries on Roman Dutch law. These commentaries were used, for example, as notes for students or guides to legal practice. Some of the important Roman Dutch jurists, who are also known as the Old Authorities, are Hugo de Groot and Johannes Voet, Voet. Their writings are still used today as a source of reference in our courts. Most people know the story of how Jan van Riebeeck, an employee of the Dutch East India Company, came to the Cape in 1652. In the early days of the business of the Dutch East India Company at the Cape, the affairs at the Cape were regulated in terms of the Ar- Article Brief. The Article Brief was a document that set out the rules and regulations governing the services of those employees of the company who were on official duty in the company's overseas territories. It was only later, when the Cape became a settlement, that the lives of the people living there were governed by the legislation or placaten. Placaten were like posters which were stuck on the walls of public places. A collection of this old placate are still to be found today in the archives in Cape Town. The following are examples of placante. A placate which stated that civil servants who did not go to church were to be punished. If this offense was committed 3 times, the person who committed it would have to spend 1 year in chains in the company prison. A placate which prohibited anyone from employing barmaids, and a placate which stated that when you when you bought a plot of ground, you had to build upon it within 1 year. The last mentioned one is not very different from one modern day municipal rules and regulations. If we look at the records of old Cape Town court cases, we will see that when there were disputes, Roman Dutch law, as discussed by the old authorities, was consulted. We mentioned above that the writings of Hugo de Groot and Johannes Fuet are still used today in our courts. This was because the practice of our courts throughout our history, and in this way, Roman Dutch law has become part of our legal tradition. It is this Roman Dutch law that still today forms the backbone of our law. Because we have this tradition, we are able to make use scientifically of the knowledge and wisdom of all the great minds who have written about and practiced law for more than 200 years. More importantly, our Roman Dutch law legal system makes it easy for modern South African lawyers to communicate and interact with lawyers in many countries across the world. The reason that they can do this is that Roman law forms the basis of the laws of almost all the countries in Western and Eastern Europe, South America, and also the laws of Japan. In addition, Roman law is still studied by the law students not only in the countries we have just mentioned, but also in other countries in Africa, Asia, in brackets it says here, notably the People's Republic of China, and in the Russian Federation, as well as the United Kingdom, Australia, New Zealand, and in some of the states of the United States of America. Now we're moving on to the third layer. It says here the third layer, English law and African customary law. The British occupied the Cape first in 1795 and then later in 1806. This resulted in the reception of English law. The British government decided that it would not deliberately change the law of its new colony, but in spite of this decision, the influence of English law was still felt, particularly after the 1820 settlers arrived in South Africa. This influence was felt both in the administration of justice and in the rules of law. For example, the British government slowly got rid of the existing court structure and replaced it with the English court structure. English became the official language. It was decided that judges and advocates had to receive their training in English. Both of these Because of this, these judges and advocates often turned to English law rather than the Roman Dutch authorities when deciding or resolving a legal problem. English law was received more formally through legislation. For example, the English law of procedure and evidence and the pro- and the For example, the English law of procedure and through legislation. For example, the English law of procedure and evidence and the jury system were received at the Cape. Trial by jury in South Africa was finally abolished in 1969, although today there are those who feel that this system should again be instituted. The English law relating to insolvency and company law was also received at the Cape. British influence was also felt in legal development outside the Cape, and then those were the years 1838 all the way to 1910. English law was increasingly received in Natal, and after the annexation of the Transvaal and Free State republics by British in the 19th century. English influence spread throughout the rest of South Africa. When Jan van Riebeeck arrived at the Cape in 19, no, in 1652, there were many different black tribes in southern Africa who lived according to their own laws and cultures. These laws were called Indigenous law and African customary law. They were unwritten laws, and it was only during the second half of the 19th century that these laws were officially recognized by the colonial authorities. Today, Indigenous law is still largely unwritten. In KwaZulu-Natal, however, much of the Indigenous law is now contained in a code which is formally recognized. It has also been recognized in various statutes in brackets legislation. In the past, Indigenous law was recognized as a special law which could be applied only to blacks. However, this has changed. In terms of the Constitution of 1996, you are asked to see Study Unit 7. The courts must apply Indigenous law where it is applicable. We must also mention that Indigenous law is Indigenous law is community based and that the role the group plays is a very important feature of this legal system. At the same time, Indigenous law regulates individual relationships between members of the family rather than relationships between individuals and the state because it regulates relationships between members of the family. It is a dynamic system that is it is capable of change. This fact has not always been appreciated by Western lawyers. The Constitution. In 1996, the first democratic constitution of the Republic of South Africa was adopted. This is an important event in the development of history of our law. We'll give more time to the Constitution in study unit 7 to 10. Now, there is an activity here. We are now on page 39. There's an activity. Activity 3.2, it says, make a short summary of most important influences in our law, in our legal history. Then use your summary to complete the diagram that follows. So on the diagram that follows, I don't like giving or going through the diagrams, especially in the recordings, because I just don't want to confuse you guys. But I see it says here Roman law, and then it gives you those dates. You remember the 753 BC all the way to 476 AD. Then it says here, make your own summary here. So yeah, now let me skip the drawing. And then there is a conclusion at the end. It says, the story of our law is a unique and interesting one. You will find this brief background of our legal history very useful when we turn to the different legal families and sources of law in the following study unit, which is study unit 4. So we were on study unit 3 that was titled The Story of Our Law. So, guys, my name is Dave. Until next time, thank you for sticking around until the end. Thank you and bye bye. I wish you the best in your studies and I wish you good luck for your exam. Thank you and bye bye.